things in the court.
The next twist in the case of 16 children removed from an Ohio home may come from their father, who's expected to make a request that could turn the entire case upside down. I'll tell you all about it. I'm Anjanette Levy, and this is Crime Fix.
16 children, one house in rural Ohio, and a legal fight that could decide whether one of the men accused of hurting them ever stands trial at all. Gary Ciders Jr. has been sitting in a jail in southeast Ohio since the end of June. He's the father of 16 children removed from a home in Vinton County, kids ranging from 18 months old to 18 years. For years, they were almost entirely off the radar. The only record anyone can point to is a single truancy complaint filed back in 2021 in a neighboring county. 16 kids, and the system barely noticed them until deputies and state agents showed up at that house. Here's what we know for certain. Gary Ciders Jr. faces 16 counts of child endangering. So does his wife, Elizabeth. So do his parents, Gary Sr. and Christina. All four have pleaded not guilty. The charges allege the children were abused and that the abuse caused serious physical harm.
Gary Ciders Jr. faces 16 counts of child endangering. His wife, Elizabeth Ciders, faces the same charges. Gary Jr.'s parents, Gary Ciders Sr. and Christina Ciders, face the same charges. All four have pleaded not guilty. Now, the child endangering charge states that the children were abused and that the abuse resulted in serious physical harm. All of the children are in therapeutic foster care.
Every one of those 16 kids is now in therapeutic foster care. Now, here's the twist. Gary Sr. is 73 and in poor health.
He's receiving treatment for a serious medical condition, and the prosecutor has said he is not a threat to the public. A competency exam has been ordered for Gary Sr. because it appears
he's already been released, and a competency exam has been ordered for him because at his first court appearance, he genuinely didn't seem to understand what was happening. Nobody's disputing that one. But his son is a different story. Gary Jr. is 36. He moved through his arraignment without any visible difficulty. He followed instructions from corrections officers, and when the judge asked how he wanted to plead, he did something telling. He asked to speak with a lawyer first.
Do you understand those pleas? How do you plead? Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel.
So Gary Jr., at least during his initial appearance, asked to speak with a lawyer before entering a plea, and Judge Rogers entered a not guilty plea on his behalf.
That's his right, of course, but it's also the kind of thing that shows some level of understanding of what's going on around you. And yet now, that same man's attorney is asking the court for a competency evaluation. Not for the father this time.
Now he has a lawyer, and that lawyer is planning to ask the court for a mental health evaluation to determine whether Gary Jr. is fit to stand trial. Attorney R. Lee Roberts has filed a motion asking Judge Rogers to allow him to file a motion requesting a competency evaluation under seal. That means we wouldn't be able to read it. Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental health condition and requests for psychiatric examination.
For him. Attorney Arlie Roberts has filed a motion asking the judge for permission to file that competency request under seal, meaning the public wouldn't get to see it. In the filing itself, the attorney says the documents concern, quote, highly sensitive mental health information. He says disclosing it would unnecessarily invade his client's privacy. He's not asking to seal the whole case, just this piece. So we're left asking the obvious question. What's in that filing that needs to stay hidden from the rest of us? There's more sitting underneath this, too. Gary Jr. also faces 4 separate misdemeanor counts of public indecency, accused of exposing himself to someone outside the family on 4 different occasions in late May. His attorney recently asked for a delay in
undergo a psychiatric evaluation. Gary Jr. also faces 4 misdemeanor counts of public indecency. He's accused of exposing himself to someone on 4 occasions between May 23rd and May 31st at the home on Omer Street. The complaint says the person Junior exposed himself to was not a family member. Now, this may be part of the reason, this competency issue, why Gary...
And it's worth wondering whether this competency question is part of the reason why. I want to slow down here for a second, because I think it's easy to get lost in legal terminology and lose the human weight of what actually happened in that house. 16 kids. Some of them reportedly couldn't speak, couldn't write their own names. Years of their lives spent in conditions described as disgusting, without school, without anyone from the outside checking in. However this case plays out in court, that part doesn't change.
I said to myself, well, he must be competent because this family knew how to evade detection. They knew how to hide. They weren't in school. How were they living? Nobody applied for social services. Do you do that on purpose so that you can live like wild animals? I'm sorry to say it, but that's kind of how they were living. The reports are when the police finally got to this family, a lot of the children couldn't speak. They couldn't write their name. I mean, this is just years and years of not being raised as we all socially are normally. And
that
it's
part already happened. And I think that's the piece that should stay with you longer than any legal maneuvering. A forensic psychiatrist who spoke about the case, Dr. Daniel Bober, said the request itself doesn't surprise him. In Ohio, like most states, defendants are presumed competent unless someone raises the question. And that someone can be the defense, the prosecution, or the judge. Competency isn't about what someone was thinking when a crime happened. That's a sanity question, a completely different legal standard. Competency is about right now. Can this person understand the charges against them? Can they work with their attorney to mount a defense? That's it.
No, it doesn't. In the state of Ohio, people are presumed to be competent. And competency can be raised by either the prosecution, the defense, or the judge themselves. So in this particular case, what we're looking at is the defendant's present state of mind. Distinguish that from their state of mind during the commission of the crime, which would be a sanity evaluation. And so we're looking at a two-pronged test. We're looking at if the defendant is able to understand the nature and the objectives of the proceedings against them, and they're able to assist in their own defense. So if they are deficient in either...
That's the whole test. And here's the part that should make you pause. Even a documented psychiatric condition doesn't automatically mean someone is incompetent. The court has to see actual evidence that a defendant can't understand the proceedings or participate in their own defense. So simply pointing at how disturbing a case looks from the outside isn't enough on its own. Criminal defense attorney Jana Spilbor put it plainly. This isn't a case like anything she's analyzed before.
The evaluation.
Okay, so in all honesty, I'm not surprised because when you examine the facts of this case, this is like no other case I think we've analyzed in my career. Like, this is a really strange case with the level of neglect that went on with so many children.
The scale of neglect over years involving that many children makes it almost inevitable that competency would get raised for someone in this family. But she was careful to draw the same line the psychiatrist did. A history of severe neglect doesn't automatically prove someone can't understand a courtroom today. If Gary Jr. is found incompetent, this doesn't mean the case disappears. It means the court decides whether he's restorable. If he is, he could be committed to a psychiatric facility for treatment, potentially for up to a year in Ohio, with the goal of eventually bringing the case back. If he's found not restorable, he could still face civil.
If he were to be found incompetent, then the court looks at, is he incompetent but restorable or not restorable? If he's incompetent but potentially restorable, he would be committed to a psychiatric hospital or some outpatient facility where they could try to restore his competency and potentially receive involuntary medication. And generally, with serious felonies in the state of Ohio, that could be up to a year. If he's incompetent but not restorable, then at some point he may be committed civilly to a psychiatric hospital if the court believes that he's guilty of the crime by clear and convincing evidence and he's still a danger to the community. He could be committed to a psychiatric hospital.
This isn't an exit from accountability. It's a detour. We're still early here. No indictment has been handed up yet. The family waived their preliminary hearings, so a grand jury still has to decide exactly what charges move forward and for whom. We don't know how many of the 16 counts will actually stick, or whether more charges are coming. And there's a detail in this case that's easy to miss under everything else. Unlike so many neglect cases, where parents live comfortably while their children suffer, every account here suggests the adults in that house were living in roughly the same conditions as the kids. That doesn't excuse anything, but it does raise a genuinely difficult question about what was actually happening inside that family for years that nobody outside ever caught. So here's where this leaves us. 16 children are now trying to rebuild a childhood they should have already had. 4 adults are fighting charges that could put them away for a long time. And one of them may never see a courtroom in the way the rest of us expect, because the law has a different definition of ready than we do. What do you think happens when a system built to protect children only shows up after years of silence? And what does justice actually look like for 16 kids who are starting from nothing? Tell me what you think should happen next, because this case is far from over.